You knew about the order and you started following her. I'm trying to figure out why you're doing that.
I was in love with her.
I'm sorry, what?
I was in love with her, Your Honor.
All right, and how old are you?
43.
All right, you may continue. 25 CR 005466 State versus Lindsay Terriano. Do I have parties announced?
Yes, Your Honor. The state of Texas.
Brian Kimbrough from Mr. Toriano.
Are you Mr. Terriano?
Yes, Your Honor.
All right, you entered into a plea. According to the plea, punishment is to be assessed at a cap of 5 years in the prison. There's a $1,500 fine. The state is opposed to your applications. They're taking in consideration 2025 AL 007223, 2025 CR 010071. There's an affirmative finding of family violence and no contact with the complainant. Have both parties had a chance to review the PSI evaluation in tab?
I have, Your Honor.
Yes, Your Honor.
Any objections?
None from the state.
No objections.
Any witnesses state?
None from the state. No.
Defense, any witnesses?
No, Your Honor, just Mr. Toriano.
All right, do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Lindsay Toriano.
All right, you may proceed.
Thank you. Mr. Toriano, we talked before you came up here today, correct?
Yes, sir.
Earlier today.
Yes, yes, sir.
Okay. And I discussed the pre-sentence report and everything that was in it, correct?
Yes, sir.
Now, in terms of the events, do you accept responsibility for what happened?
Yes, sir.
Was it your fault?
Yes, sir.
Yes. You have been on probation in the past, correct?
Yes, yes, sir.
A number of times.
Yes, sir.
And have you completed all of your probation successfully?
Yes, sir.
I think you had one prior felony probation that you were on, correct?
Yes, sir.
And you completed that.
Yes, sir.
And your misdemeanor probations, you also completed those, correct?
Yes, sir.
Have you ever been to prison?
Never been in prison, sir.
Okay. Were you employed at the time of this event?
Yes.
And how long had you been employed?
8 years.
And do you believe that you could get a job if you were placed on community supervision fairly quickly?
Yes, sir.
Is it your habit to keep employment for a long time or a short time?
For a long time, sir.
Okay. Now, you have family support, correct?
Yes, sir. My 87-year-old grandma, she's here.
Okay.
And I'm uncle also.
And so your grandmother and your uncle are here in court today in support of you, correct?
Yes, yes, sir.
And your grandmother is 90, right?
87.
She's 90.
Yeah.
Just spoke to her. She's 90 years old and she's here today.
Yes, sir.
And your mother was not able to attend, is that correct?
That's correct.
Because she's in California.
That is correct.
But you have a good relationship with her.
Yes.
So you have a lot of support. Do you tell the judge why you think you could succeed on probation?
I can succeed because I want to be there for my grandmother and my family, and I just want to move forward with my life and continue my career as a network technician. I apologize for anything that's caused and apologize to everybody, and I love everybody.
Do you have any substance abuse problems,
No.
drug problems, alcohol problems?
No.
Okay. You're a high school graduate, correct?
Yes, sir.
And you were also intending, or did you attend technical school?
Technical school, 2 years.
And counsel, I'm so sorry to interrupt. This is what I want to know.
Mhm.
Because he's applied for probation on a violation of bond protective order, assault, stalking. I want to know why he won't leave this lady alone, because it appears she doesn't want to be involved with him anymore. So that's what I want an answer for, because we're here because there was a court order in place saying you were not to have any contact with her. The stipulations were that she was out with friends. You all were not together and you followed her and you wouldn't leave her alone. This is what you stipulated to, right? I want to know why he won't abide by court orders.
No, I was, Your Honor. I apologize, but
No. I don't. I appreciate your apology, but that's not what I need. I'm trying to figure out why, because a court has ordered you not to have contact with her. According to what you stipulated to, she was out with friends and you were stalking her. You were following her. You violated the bond, the protective order.
yes, Your Honor.
I want to know why he's violating the protective order, because that's an order, right?
Yes, Your Honor.
And it says you are not to do certain things. And according to what you stipulated to, you did those certain things.
Yes,
If I were to place you on probation, I'm going to order that you do certain things.
yes,
So
Your
I'm trying to figure out why you didn't follow the previous order.
Honor.
What do you mean it was a mistake?
Mistake, while we were talking, that's
Well-
the reason why I was put it up.
There's an order in place. You're not supposed to do that. Are you saying you didn't know about the order?
I didn't know about it.
All right, so then it's not a mistake that you talked to her. You knew about the order and you started following her. I'm trying to figure out why you're doing that.
I was in love with it.
I'm sorry, what?
I was in love with it, Your Honor.
All right, and how old are you?
43.
All right, you may continue.
And I did want to point out, Judge, that based on the stipulations, I don't dispute what the court's saying. However, there's also, and I reviewed it before coming forward today, that she went to his apartment and it was from the bar to his apartment, and she doesn't indicate that she was forced to go there.
Okay.
So she was there, and then he was there, and of course, he was in violation of the order. Do you believe that you have learned that what you did was wrong?
Yes, yes, sir.
Will it ever happen again
No, sir.
with that woman or any woman or man
That is correct.
that has an order in place that you cannot be around them?
I understand.
Will you do it
Never
again?
happened. No, sir. No, Your Honor.
Do you believe that part of your motivation was your emotional attachment,
That is correct. Yes, sir.
but now your brain is involved, correct?
Yes.
Your reasoning is involved. Will it happen again?
No, sir.
All right, so this is what it says in the stipulations. Making location, I spoke with victim one who stated that she went out to a local bar with friends, and that is where the original contact with S1, your S1 suspect, occurred. Victim stated that she did not invite or notify the suspect of her location, and the suspect follows and stalks her. Suspect made contact with her and told victim that she needed to go back to his residence to pick up some clothing that belonged to the victim. The victim went to the suspect's location, and victim stated that she got into an argument with the suspect. Victim stated that as she tried to leave his residence, suspect began to make physical contact with victim and bit victim on her right upper arm. Victim attempted to leave the location and rushed down the stairway. Victim stated suspect dragged her up the stairway in an attempt to prevent victim from leaving. This resulted in victim getting bruising on her left leg. Victim stated she then left the location, and that is when she called the police to notify them of the incident. Those are the stipulations. All right, this is what the court is going to do. Court is going to find you guilty. The court will sentence you to 5 years in the prison, give you credit for any time served. Taking consideration 2025 AL 007223, 2025 CR 01007. There's affirmative finding of family violence. There's to be no contact with the complainant, and the court will give you credit for any time served. The court will recommend therapeutic community to address any mental issues. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it?
Yes, sir.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, so we are off the record. What I can tell you is the complainant no longer wants to be in a relationship with you. When you're released, if you have any items of hers, drop them off at the police station, wherever it may be. You
I
understand?
move on with my mom. So
Okay.
I just want to go to California.
All right, good luck to you. And counsel, if you remain, state will give you the dismissals.
Oh,
Thank you.
Triano?
You're charged with unlawful possession of a firearm by a felon. That's the 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering that plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Mendez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $2,000 fine, no applications. This will run concurrent with 2020 CR 2487. State will take in consideration 2025 PF 37392, 37393, 37395. Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Not in this case, Your Honor.
Then to the offenses filed, how do you plead? Guilty, not guilty, or no concept test?
Guilty, ma'am.
State, any evidence?
It offers states one.
Any objections?
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, but I do have a request in that regard, Your Honor.
Yes,
And it's concurrent with disposition of the MTR.
yes.
As the court is no doubt aware, the last legislative session amended the Code of Criminal Procedure, Articles 27.20,
Yes,
concerning the necessity for confinement upon plea of guilty or no contest.
yes.
I've submitted written briefing to the court that I filed just yesterday afternoon in support of the request for allowing self-surrender of Mr. Mendez. In my reading of 2720, it appears that the mandate, the shall, concerns offenses enumerated under Article 42A.054, or what we call our 3G offenses. Mr. Mendez's probation, as well as the new case that he's pleading to today, are non-3G offenses. I'd submit to the court that Mr. Mendez has been strictly compliant with the conditions of bond in this case. He self-surrendered promptly when an MTR was triggered by his new arrest. He's been to court, he's been reporting, he's been compliant with conditions imposed as part of his bond. The ask is that because Mr. Mendez, and it's really a twofold basis for the request, he's a small business owner where he's been
diligently trying to get things in place to allow the business to continue operating while he's in. It's a moving company, a pretty successful one. And two, he's the father of a 12-year-old. We'd asked for 45 days to allow him to have one more holiday season with his daughter before he goes in to serve his time. I think he's demonstrated a willingness and obedience of the court's orders. And so we'd ask for the court's mercy in granting that request, whether it be a sentence today with self-surrender or reset for sentencing so that the court could expose Mr. Mendez to a fuller range of punishment for a failure to comply. So our kind of alternative requests.
All right, Mr. Mendez, you're currently on deferred adjudication for a first-degree felony. So the the request for self-surrender will be denied. The court is, as previously stated, the court is finding you guilty. The court will sentence you to 5 years in the prison. There's a $2,000 fine, time and money to run concurrent. This will run concurrent with 2020 CR 2487. Take in consideration 2025 PF 37392, 37393, 37395, and the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you will need to speak to an attorney. All right, let's move on to the motion to revoke. Counsel, did you do a trial court certification on the motion to revoke?
I did, Your Honor.
All right. Thanks. Court is calling 2020 CR 2487. Could I have parties announced for the record?
Now we proceed.
Christian Noon for Mr. Mendez.
Mr. Mendez, I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review that document with your attorney? Did you understand it? Are you the same Christopher Mendez who was placed on community supervision in 2020 CR 2487 for the offense of manufacturing delivery, a controlled substance penalty group 1, 4 to 200 grams?
Yes, ma'am.
All right, state.
Violation of condition number 1 on or about the first day of September 2025 in Bear County, Texas. Defendant Christopher Mendez committed the offense of unlawful possession of a firearm by a felon in violation of.
How do you plead to that?
And we waive and abandon our opinion here.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, court could find it true, grant the motion, sentence you up to 5 years in the prison and up to a $1,500 fine? Knowing that, do you still wish to plead true to violation of condition number 1? All right, court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, it's to grant the state's motion for both the defendant's community supervision and sentence him to this underlying 5 years in prison to run concurrent with the case.
All right, and what was the previous case number?
2025 CR 014524.
All right, Mr. Mendez, are you asking the court to follow that agreement? Are you waiving your right to appeal? All right, the court will follow your agreement. The court is finding violation of condition number 1 true. The court will sentence you to 5 years in the prison. This will run concurrent with 2025 CR 014524. There's a $1,500 fine, time and money to run concurrent, and the court will give you credit for any time served. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Mr. Mendez, sometimes, hands are tied, right? But I want to let you know, I do appreciate your turning yourself in. I appreciate your showing up on time, and I appreciate your being dressed appropriately, even probably knowing beforehand that you had worked out an agreement for prison time. I wish you the best, okay? You're welcome. Who else is ready?
What unfolded in this courtroom today was a stark reminder that love is never a legal defense and that a court order is not a suggestion. Lindsay Toriano, 43 years old, stood before the bench facing charges of stalking, assault, and violation of a bond protective order. The facts were damning and undisputed. A woman had gone out with friends. She never told him where she was going, and he found her anyway. He followed her. He made contact. He lured her back to his residence under the pretense of retrieving her belongings, and once she tried to leave, he bit her on the arm, dragged her up a stairway to prevent her escape, and left her with bruises on her leg. She had to call the police just to get out safely. When Judge Boyd pressed him point blank why he kept violating the protective order, Toriano's answer was that he was in love. The judge didn't flinch. He wasn't buying it. Because love doesn't stalk. Love doesn't bite. Love doesn't drag someone up a staircase against their will. The court sentenced Toriano to 5 years in prison, issued an affirmative finding of family violence, and ordered no contact with the complainant. Off the record, the judge added something telling. The victim no longer wants a relationship with you. Move on. The second case, Christopher Mendez, brought its own weight. A man already on deferred adjudication for a first-degree felony, caught with a firearm as a felon. His attorney made an emotional plea for a 45-day delay one last holiday with his 12-year-old daughter. The court denied it. 5 years. Concurrent. Immediate. 2 cases. 2 defendants who made choices that cost them years of their freedom. The courtroom doesn't grade on emotion. It grades on conduct. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns because justice never gets old.